we'll begin with page 1. Page 2. Page 3. That's it. Could I have confirmation of the minutes? Moved by member Gill. Second? Member Braham. Are there any corrections to the minutes? Any items arising? All right, the item arising would be the draft report to be reviewed. So here we are with all members having looked at it. I know that there are some track changes from our technical team. New track changes, and so we will go through that report. All right, so we do have some comments on this version of the draft bill. Draft report, sorry, I'm anxious again, way too anxious. And so members, should we read or just go to where the comments are? You can give us some guidance? Read? All right. All right, so I'll start. Draft report.
Sorry. Sorry, go ahead. My apologies.
Draft report on the deliberations of the Joint Select Committee appointed to consider and report on the bill shortly entitled the Jamaica Teaching Council Act 2022. Number 1, establishment, composition, and powers of the committee. Members of the House are reminded that on the 10th day of February 2022, on a motion made by Honorable Favour Williams, MP, the Minister of Education and Youth, after the suspension of the standing orders, the House of Representatives passed the following resolution. Be it resolved that notwithstanding Standing Order 76-1, this Honorable House appoint a select committee comprising the following members: Honorable Favour Williams, MP Chairman, Honorable Robert Nestor Morgan, MP, Honorable Floyd Green, MP, Honorable Juliette Cuthbert Flynn, MP, Ms. Tova Hamilton, MP, Ms. Rhoda Moy Crawford, MP, Dr. Angela Brown Burke, MP, Mrs. Natalie Nita Garvey, MP, to sit jointly with a similar committee to be appointed by the Senate to consider and report on a bill shortly entitled the Jamaica Teaching Council Act 2022. And be it resolved that the committee be empowered to hold virtual meetings, be they partly or wholly virtual from time to time. Members of the Senate are reminded that on the 10th day of February 2022, on a motion made by Senator the Honorable Kamina Johnson-Smith, Minister of Foreign Affairs and Foreign Trade and Leader of Government Business, after the suspension of the standing orders, the Senate moved the following resolution. Be it resolved that this Honorable Senate appoint a select committee comprising the following members: Senator Ransford Graham, Senator Cavan Gale, Senator Natalie Campbell Rodriguez, Senator Lambert Brown, Senator Gabriela Morris. Members are reminded that Senate Standing Orders 74B and C allow for members of the Senate to participate in meetings held in a virtual space created using information and communications technologies, ICT. Members are further reminded that by virtue of a resolution approved by this Honorable House on the first day of February 2022, the composition of your committee, as set out above, was made to continue in force for this session of Parliament, and we were empowered to proceed with matters that were before us from the stage reached at prorogation. A similar motion was approved in the Honorable Senate on the 4th of February 2022. Members are also reminded that by virtue of a resolution approved by this Honorable House on the 10th day of February 2023, the composition of your committee as set out above was made to continue in force for this session of Parliament, and we were empowered to proceed with matters that were before us from the stage reached at prorogation. A similar motion was approved in the Honorable Senate on the 7th of February 2023. Members are further reminded that by virtue of a resolution approved by this Honorable House on the 6th day of February 2024, the composition of your committee as set out above was made to continue in force for this session of Parliament, and we were empowered to proceed with matters that were before us from the stage reached at prorogation. A similar motion was approved in the Honorable Senate on the 2nd of February 2024. Members are further reminded that by virtue of a resolution approved by this Honorable Senate on the 26th day of May 2023, as a result of the resignation of former Senator Natalie Campbell Rodriguez, the Honorable Senator Dana Morris Dixon was appointed to serve on the committee. We move to the next section, establishment, composition, and the powers of the committee continued. Overall, your committee held 38 meetings to deliberate on the bill shortly entitled the Jamaica Teaching Council Act 2022, which commenced during the 2021-2022 parliamentary session on February 15, 2022, see Appendix 3. We agreed that stakeholders and the wider public would be given an opportunity to make submissions on the bill. In that regard, we wrote to a number of organizations and published public notices in the Jamaica Observer and the Gleaner on the 20th and 27th days of February 2022, inviting written submissions from individuals and organizations. See Appendix 4. Your committee, at its first sitting on February 15, 2022, decided to give an opportunity to stakeholders and the wider public to make submissions on the bill. In that regard, your committee wrote to the Jamaica Teachers Association, Ecumenical Education Committee, Edifocal Limited, Jamaica Association of Guidance Counselors in Education, Jamaica Association of Principals in Infant and Primary Schools, Jamaica Association of Principals of Secondary School, Jamaica Council of Churches, Jamaica Independent Schools Association, Jamaica Union of Tertiary Students, Ministry of Education and Youth, National Parent Teachers Association, National Secondary Students Council, Northern Caribbean University, NCU, Private Sector Organization of Jamaica, Teachers College of Jamaica, University of Technology, Jamaica, UTEC, University of the West Indies, MONA, and the Youth Advisory Council. Your committee, first appointed to consider and report on the bill, received submissions and oral presentations from the following groups: the University of the West Indies, MONA, School of Education, the University of Technology, Jamaica, UTEC, Teachers Colleges of Jamaica, TCJ, Jamaica Teachers Association, JTA, National Parent Teachers Association of Jamaica, the Ecumenical Education Committee, Jamaica Association of Homeschoolers Society, and that comprise Suze Rattigan, Vitale family, Pearman family, Murphy family, C. Danielle McNish, Maurice Saunders. The technical teams were present from the Jamaica Teaching Council, JTC, the Office of the Parliamentary Council, OPC, the Attorney General's Chambers, the Ministry of Education and Youth, and the Legal Reform Department, LRD. Moving to overview. The Teachers Services Commission is charged under Section 32 of the Education Act 1965 with the responsibility to deal generally with the registration, discipline, and assessment of the qualifications of teachers. In addition, the TSC provides advice to the Minister on matters relating to the appointment of principals, vice principals, and teachers with special responsibilities. The Education Act and the Education Regulation 1980 do not sufficiently address the needs of the current education environment. A decision has been taken to enact legislation to provide for greater accountability within the teaching profession and for a framework that facilitates increased productivity within the profession, while at the same time improving the status of the teaching profession. In response to the recommendations contained in the report of the Task Force on Education Reform, 2004, there is need for the establishment of the Jamaica Teaching Council, JTC, to deal with, in a more fulsome manner, the functions of the TSC under Section 32 of the Education Act. The JTC will be a statutory body charged with the responsibility to regulate the teaching profession and to contribute to the overall improvement of the performance standards of teachers and the quality of education provided to students. Consequently, this bill seeks inter alia to A, repeal the functions of the TSC relating to the registration, discipline, and assessment of the qualifications of teachers along with certain other provisions of the Education Act. Repeal certain provisions of the Education Regulations 1980, establish the Jamaica Teaching Council and define its functions, and deregulate the practice and professional conduct of teachers and instructors and other persons to whom this act applies. Findings and recommendations. Your committee now has the honor of presenting its findings and recommendations after an extensive review of the bill. General recommendations. 1. Usage of the terms board and council. The bill establishes the Jamaica Teaching Council, Clause 6, and a board, Clause 13. Your committee extensively deliberated on the suggestion to delete references to the board of the council and simply refer to the council. We decided to retain the distinction in the bill because the roles and the functions of the council and the board were clear and distinct to justify having them as two separate entities.
Yes, sorry, Chairman?
Yes,
May I
please
hear?
go ahead, yes.
You'll notice this is the first point on which these chambers had a comment, and we're essentially inviting the committee to reconsider this decision. But having looked back at it, I think it might be best to address our comment perhaps at the end, after we've had the chance to look at the various provisions to see how they interact. That might provide a better way to think about the distinction between the board and the council in the context of the bill. And might be a more efficient review process of the report as well.
Okay, but could I just ask a question? Because when I look at council and bill, I'm thinking that the JTC, only because we call it a council, we could have called it the Jamaica Teaching Company, right? Which would have to have a board. Go ahead, member.
Mr. Foreman's position, I'm not sure the reason for it, but I think that either way, we could wait until we have gone through, but it's a matter of what we decide to call it. But I think I'll wait and see exactly what he has in mind.
Okay, thank you, member. All right, let's move on to item 2, long title and enabling clause. Your committee noted the stakeholder query whether the statement in the long title that the bill seeks to recognize and promote teaching as a profession implied that teaching was not currently recognized and promoted as a profession. In our deliberations, we observed that the bill intends to set the framework for the teaching profession and noted that the proposed alternative words of advance in combination with the word formalize better reflected the intention of the bill. Your committee recommends that the words recognize and promote be replaced with formalize and advance. All right, we'll keep going.
Minister Green, you may need to mute yourself. You're unmuted at the moment.
Ladies and gentlemen, I'm asking we stand for the playing of the national anthem.
Sir Clark, can you mute Minister Green? I don't think he realizes that he's unmuted.
Good afternoon, members.
Yes, looks like we're good to restart. So we'll do again the long title and enabling clause. Your committee noted the stakeholder query, whether the statement in the long title that the bill seeks to recognize and promote teaching as a profession implied that teaching was not currently recognized and promoted as a profession. In our deliberations, we observed that the bill intends to set the framework for the teaching profession and noted that the proposed alternative words of advance in combination with the word formalize better reflected the intention of the bill. Your committee recommends that the words recognize and promote be replaced with formalize and advance. If there are no further corrections or additions or comments to this, could we just get an okay from members? Approval, acceptance? Agreed. All right, Senator Gale, you want to pick up part one, preliminary?
Part 1, preliminary, clause 1, short title and commencement. Your committee does not recommend any change to this clause. Under clause 2, interpretation, definition of approved home education program. Your committee noted the queries whether by virtue of the definition of approved home education program, parents would be required to be licensed under the bill. Your committee concluded that neither a licensed nor an authorized to teach should be needed for a parent who teaches their child, and no other child, and recommends amendments to the appropriate provisions of the bill to give effect to this decision.
Any comments? If not,
That's what we agreed to.
Okay, all right.
Definition of teach. Your committee acknowledged the stakeholders' concern that based on the definition of teacher and teach and its impact on persons who now tutor, the services provided by unlicensed teachers or instructors would be undermined, ostracized, and criminalized. Your committee acknowledged the concerns, but agreed. Your committee acknowledged the stakeholders' concern that based on the definition of teacher,
Please,
your committee
please
acknowledged the
mic.
concern, but agreed with the policy reflected in the bill, which is
I'm
to
sorry,
include.
hold on, member. For those persons online, could you please mute? Otherwise, if you want an intervention, please raise your hand. All right, let's continue.
So I can now proceed.
Yes, please continue, member. Please mute everyone. Member Green, do you have a question?
No.
Who needs to mute? Member Green, please mute.
Member Green not listening. Continue. Your committee acknowledged the concern, but agreed with the policy reflected in the bill, which is to include tutors in the category of persons regulated by the council. We noted that persons who would not meet the qualification necessary to continue to tutor when the bill is enacted would be given an opportunity to become qualified and therefore would not automatically be at risk of sanction.
I remember this, Chairman, about tutors and people who volunteer. There was a lengthy discussion about it. Sorry. There was a lengthy discussion about it, and I had a concern myself as to whether these persons were to be excluded. But I think the members, the majority, thought that everybody should be qualified. If you want to volunteer, you qualify. If you don't, otherwise don't volunteer. I don't like that, but that was the majority decision. I happen to think that there should be a separate category for those persons. But we're not going back over it.
All right. All right, so members, we approve. Definition of teach. Please continue.
So we can approve that, and then we continue now on page 6. Your committee recommends amending the subparagraph A, subsection 3, and in the definition of teach, to refer to teaching support services instead of the services. Your committee noted the stakeholder observation that the definition of teacher excludes most teachers at the early childhood level because such teachers are trained to the vocational level. The stakeholder also indicated that there's an apparent conflict between the bill and the Early Childhood Act because the latter act empowers the Early Childhood Commission to prescribe qualifications of teachers at that level, which raised the question whether the Early Childhood Act or the provisions of the bill, when enacted, would take precedence. Your committee acknowledged the stakeholder concerns and noted that in the context of the transformation of the early childhood education system, that the Early Childhood Act may need to be amended. Your committee recommends that appropriate amendments be made to the Early Childhood Act pending checks of the final version for confirmation. Your committee also considered questions regarding the effect of the definition of teacher on the Education Act. Your committee recommends that the amendment of the Education Act to reflect the updated standards in relation to categories of teachers as outlined under Schedule A of the Education Regulations.
Okay.
Do we want to
Mr. Foreman,
comments now?
do you want to give your comments on this? I know, obviously you have extensive written comments. If there's anything else you wish to say, please go ahead.
Nothing to add to what is written there, but I suppose I could just summarize the essence of it, which is that the regulations under the Early Childhood Act do have provisions in there which require persons in those institutions who are teaching to have the qualifications prescribed in those regulations. So when this bill comes into effect, and the fact that the bill is stated to apply to early childhood institutions as well, you're going to have two different pieces of legislation, an act and a regulation made under specific legislation, speaking to slightly different things in relation to qualifications to teach. So in a circumstance like that, it would be appropriate, we think, to reconcile the two. If the intention is that the Teaching Council Act will be the legislation that governs the teaching profession, broadly speaking, one path that the committee may wish to consider is to amend the regulations under the Early Childhood Act to stipulate that the teacher in that institution should be a licensed teacher pursuant to this bill, or to this legislation, and becomes legislation for the consideration of the committee.
So the policy is to remove the regulatory sort of qualification from the education, the Early Childhood Commission entirely. Is that the policy?
Chair, Good afternoon, and good afternoon to members and colleagues online. Based on the current policy of the ministry, the teacher training institutions are no longer issuing diplomas, and so by virtue of that, also the Early Childhood Commission Act, that regulatory section would need to be amended to be in keeping with our current policy.
Trying to, at the moment, the commission does provide some guidance or qualification standards for the persons who operate in the basic schools, many of whom are, should I say, differently trained than the teachers above the basic school level. So is it that we are going to take those functions from the commission and vest it entirely in the new council? Or they are going to run dually and we just need to equalize the things that they have to take into account? I think it's an important question for us to decide. And I don't.
Sorry, Chair, may I just read the
Yes,
comment
please
that I
go
made?
ahead.
Right. Section 15.4 of the Early Childhood Act empowers the Commission, that is the Early Childhood Commission, to make regulations prescribing qualifications in respect of operators and employees of early childhood institutions. This power has been exercised to meet the Early Childhood Regulations 2005. Regulation 6.1 requires applicants for registration under that act to show that the operator and every employee has the qualifications prescribed in that provision. These include, for example, training in early childhood development, training in pediatric first aid, training in recognizing signs of child abuse. So all employees at these institutions must have those qualifications, well, training in those areas, whether you're a teacher or an accountant in an office or something of the sort, but all employees. The regulations also indicate that a qualified teacher must be employed to the institution if it provides care for any children over the age of 36 months. Qualified teacher is defined as a person who has at minimum been issued a diploma by a recognized teacher training college. The regulations also prescribe minimum levels of education needed for different classes of teachers. For example, a lead teacher should have the qualification of a bachelor in education or a diploma in teaching, while an associate teacher should have the NCT vet NVQJ level 3 or associate degree in EC. I think by EC I meant early childhood education. So that's the legislative context at the moment, and we are very strongly recommending that you be clear on the standard that you want or the qualifications that you want to obtain in relation to persons who teach at the early childhood level. Because if we have two separate pieces of legislation on the face of it saying different things, at some point there's going to be dispute as to which one applies. Legal opinions will have to be written, which, if we can avoid all of that, it would be helpful.
Thank you, Mr. Foreman. The technical team is conferring.
Yes, Chair. So based on our discussion just now, the standard would have to be that of the Jamaica Teaching Council. And so if based on that, the Early Childhood Commission Act would have to be amended to be in line with the relevant standards.
I'm just would ask us to the policy framers to look carefully at the Early Childhood Act. That act was promulgated with certain things in mind and certain realities in mind at the time. It may be that those realities no longer exist, but up to last week I was in a community and I see some of them still exist. So it will be very important and useful that the policymakers consider whether bringing the Early Childhood Commission legislation entirely in line is what is required now. Should there be a transitional period? Things like that. But I suppose those could be considered during the course of amendment when the amendment is being taken.
There is a transitional period involved in that.
Chair, I recall too that there was a discussion based on the definition of teacher and the matter of the early childhood institutions. And as a result of that, the definition of teacher was amended to indicate the textbook equivalent of a degree. And so in terms of the definition under the Early Childhood Act for a qualified teacher, then that would definitely have to be amended. But under the early childhood scheme of things, you have like caregivers who are not teachers. They are caregivers, but they are not teachers because they have a different classification. And so once we examine the act, we will ensure, as Member Braham indicated, that we consider what would have been considered at the time when the Early Childhood Commission Act was promulgated to ensure that there is no issue with those policies.
Is that having passed this act, the next day, much of those who operate in the early childhood sector become illegal.
No, member, I think there will be sufficient time for them to get qualified. Council, can you council?
Chair, I'm not seeing a provision in relation to those persons who would have a lesser qualification, but I know based on the discussions that were had in previous meetings, there were indications that there are some programs in place now to have those persons obtain the relevant qualifications before the bill is passed. Not before the bill is passed, but to ensure that they have the relevant qualification in order to be registered and licensed as a teacher.
So in this case, is there an applicable transition period to allow them to be part of any such provision? I take it that at this particular level of teaching, it is where a lot of teachers enter the profession, especially in some areas. Some communities depend on this level. We don't want for this particular grouping to align a similar threshold to that of the primary and secondary level. And so I'm trying to understand whether or not this grouping can afford itself as part of any transition period.
Good afternoon, Minister. Good afternoon, members and my colleagues here. The teacher is a teacher regardless of the level at which the person teaches. The person is a teacher and has to satisfy the requirements of a teacher. Now, for the early childhood program, at present, the person with a level 3 qualification in the heart early childhood program is allowed to teach. And under the legislation, that person will be authorized to teach. So the legislation will not deprive the early childhood program in any way of its opportunities.
So what I have in mind is probably a little bit more practical. I agree that the heart, let me use NCTVET program qualification is used at the moment, but several persons don't have that qualification. I mean, that's a fact, they don't. Some are enrolled, but it appears then that they're going to have to be a mass enrollment program and to ensure that all of them get in the program, because if the ones who are not qualified simply just fall out of the system without a transition, it's going to be problematic. So that the government may well have to consider the facilitating of these people, getting them into the program. We are used to doing it because I know in the past, diplomas and all of those, there were a transitional period to allow it. I just don't want to wake up one morning to hear that the others who don't have the qualification, speaking as a former board chairman of a basic school, I have a little touch of experience. That's why I'm sort of urging us to take it into consideration.
So, I'm sorry, could you get on? Okay. Okay, go ahead.
Early childhood education is fundamental to human development. It is fundamental to any further education. And so as we move forward into the new era, we have to do all we can to ensure that the teachers at that level are qualified. At any rate, there will be consideration for the timing and so on. but they ought to be qualified to teach. Remember, they are caregivers. The caregivers are fine, but the persons who are teaching, they should be qualified to teach.
So I think,
To the misunderstanding, Chairman, I agree 2,050% that they must be qualified to teach. All I don't want is the timing so that you just pitch out people without giving them the opportunity to get themselves up to speed.
okay, so there has to be in this, if it's not there already, some period of time that is allowed for persons to be qualified at the early childhood level to teach. Oh, the early childhood, go ahead.
The Chair, as Dr. G indicated earlier, those persons will get an authorization to teach, and the authorization to teach lasts for 2 years, and it can be renewed for further periods not exceeding 2 years for each period. So if it is that those persons, during them being operating under authorization to teach, they can get the requisite qualification in order to be a licensed teacher. So that provision is there for those persons who would not have met the criteria to be issued a license.
Or SG, please come in.
Hi, good afternoon, Chair. Good afternoon, members and colleagues. I've heard what Mrs. Gordon-Jones says, but I'm wondering where is that in the bill? Because intentions are always great, but you have to see what's in the bill. I'm looking at clause 81, and I'm wondering if it addresses the issue, or if it doesn't know, that maybe we could be given time to study it and see if we can apply it to this situation, if it does not yet apply. And that would be my suggestion. I don't think it is good enough to just speak about what we intend and so on. We need to see what's in the bill, and if the bill doesn't address the issue adequately, then amendments would need to be proposed. So it is in that context I'm looking at clause 81 and suggesting that others also look at clause 81, and perhaps we pick this discussion up at the next meeting. So I think there needs to be a little bit of study of the bill. And if 81 doesn't apply, I noticed even clause 82, which wouldn't apply, but perhaps it could be tweaked to address the early childhood, the persons who fall under the Early Childhood Act, or perhaps other transitional provisions. And that would address what I've just said, would address, or hoping it would address the concern raised by Senator Graham, but just to remind the committee of the other concern expressed by Mr. Foreman of these chambers, where we do not think it is wise to have a duplication of requirements, and it may not even be a proper duplication. We don't think you should have requirements in 2 acts, early childhood and this bill, because if they are not identical, it can create problems. And if they're identical, you don't need a duplication. So again, those are the matters that we would bring to attention. And I think that persons need a little time to digest and review, and then perhaps at the next meeting the committee can take some decisions. Thank you.
Thank you, SG. Mrs. Gordon-Jones, you have a further intervention?
Indicate, Chair, that the provision that I was reading from was under clause 44, which speaks to the validity of the authorization to teach. So that's where I was referring. Clause 44.
Do you mind just reading what it says?
Chair, if I may ask?
Please go ahead.
Right, but this is talking about an authorization to teach granted under the Act. Remember, now you may have persons who would not have had an authorization to teach granted under the Act. So that is where, so basically what Senator Brown is talking about is like a grandfathering clause, a grandfathering provision, which we do all the time when we're coming in with a new regime, a new scheme, and we have persons who could potentially fall outside of that scheme, to give them some time to get caught up and to be included in the new scheme. It's a regular feature that we use. Thanks.
So members, I think we definitely would like some kind of a grandfathering act for those who are existing, and for them to be given time to get to the proper level to be teaching in the early childhood sector.
So before I proceed, are we going to await some sort of a proposed amendment in this case?
Yes, member.
Okay. Right. So I will continue on the definition of teach.
Sorry, member.
Sorry.
I thought you said, are you going to? Sorry. I
No.
meant we'll just wait. No?
No, I don't
All right.
take it that it is going to come now.
Oh, okay. All right.
I take it that would give them some time to make that determination and get back to the committee.
Okay, member.
So, in continuing, definition of teacher aide and teacher assistant. Your committee recommended the removal of the terms teacher aide and teacher's assistant. Your committee noted the submissions regarding the feasibility of having the total teacher cohort qualified with a bachelor's degree in education, and whether in-service training would be provided for those without the qualifications. Stakeholders also questioned whether teachers would be given time and funding to meet the qualifying requirements. We acknowledge that the concern questions the impact of the bill on persons without the required qualifications. Your committee indicates that there would be a period of time for persons to upgrade themselves before the act takes effect, and that the bill has transitional provisions to facilitate persons into the new system. If we had just gone ahead and read. Your committee acknowledged the query whether lecturers in tertiary institutions fell under the designation of teachers, given that many did not complete a first degree in education or related courses, but had basic qualification that exceeded a first degree. Definition of teacher aide and teacher's assistant continued. Your committee noted that the bill applies to the schools and educational institutions described in Clause 4, and that in relation to tertiary institutions, the bill only applies to persons who teach in an education program that prepares persons to become teachers. We acknowledge the rationale given for this position is that persons who intend to train teachers should themselves be trained teachers. Inclusion of definition of,
Sorry,
no.
one moment. So we are on that definition, still on the definition of teachers' aid and so on. And the committee noted that the bill applies to schools and education institutions described in Clause 4, and that in relation to tertiary institutions, the bill only applies to persons who teach in an education program that prepares persons to become teachers. And I'm wondering if that's so in a teacher training institution that we have, everybody there, and so they're teaching so on. All the persons who are teaching in teacher training institution have to be qualified teachers. Every day they get one.
Well,
is that reasonable?
If you look at the clause 4.
I'm just reading from it. Says it says here that persons who teach in an educational program that prepares persons to become teachers. Those are the persons, and that sounds to me that we are saying, I'm doing my BSc in education. The persons who teach in that program all have to be qualified teachers. Not a specific set of people, but everybody. Is that practical? That's what I'm asking.
But it goes in conjunction with clause 4.
What clause 4 is it?
Who the act applies to.
Yeah, clause 4G does say that this act applies to a person who teaches in an education program that prepares persons to become teachers. I know it says that, but I am still asking the question whether we should have, if it's not onerous to these tertiary institutions. What up?
You're not moving on the screen.
So?
There's a pause.
Okay. Well, I didn't feel froze myself, but but I would like
All right, I think I understand what you're saying in terms of, for example, we are quite short of physics teachers. So you might find a graduate in physics who can contribute to the professional development of a teacher in a teacher's college. Nonetheless, the college would have to guarantee that the professional aspect of the teaching of physics is taken care of, because the person who is coming in to teach physics can teach the contents on, but not the professional dimension. So the bill gives opportunity for that person to be authorized to teach, and to be authorized to teach, whether it's in a school or the teacher's college. But at the same time, we have to ensure that where that happens, then the teacher's college has a responsibility to provide the professional dimension of that person's teaching. Is that clear? So you can take the physics person, the person will teach the content of physics, but how do you teach physics?
Case, the application for the authorization to teach would have to be made through the council. And suppose it's a situation where you need that person immediately for a temporary basis to fill a gap. Are you saying to us that that person would have to go through that level of application as defined in 43?
I think they are back now. I think. Manage the institution and you get your feature. You know, you can't make this thing so rigid, man. The only thing I would say, Chair, to look at it, and while it is necessary for the professionalization and so on, but we can't make it so rigid that it is difficult to run an institution. And I do appreciate that you do need a certain amount of persons in the institution who know how to teach and to teach people how to teach and so forth. But there are going to be other things that the teacher learns as a part of his or her degree that you don't need to have any qualification about teaching for them to learn about that. Anyhow, just a thought I have.
But it's a good thought.
It seems to me that we are looking at the administrative process to get an authorization to teach. No, I see no reason why the council should delay a response. It can investigate quickly, and give a response to the college or the institution that requires that person who is not a trained teacher to teach teachers. So I don't see it as a problem at this time. I don't see the problem.
Could you say what happens currently in let's say, UWI that has a teacher education facility?
The college takes on a person with the understanding, with the request to the Ministry of Education to approve eventually that person. But if the person is urgently needed, the college goes ahead.
I think we should reconsider this sentence that says they themselves should be trained teachers. we're saying that the persons who teach at the tertiary level, who teach in an education program that prepares persons to become teachers, they themselves should be trained teachers. So we're saying, let's say somebody has a PhD in physics and they're training teachers to be physics teachers, they themselves have to be teachers, as trained teachers. That sounds, yeah, it does sound a little bit onerous. It sounds onerous. Straight jackets.
You have today, in today's society and environment, a number of persons who are lecturers, who are trainers, who are competent in a particular area. Let's say someone competent in banking, in finance. They are not trained teachers, they are not qualified teachers, but they are in an institution delivering the services as trainers. And they don't have the time to be able to go to qualify themselves as a trained teacher, but they are offering the services of being an educator. And so are we saying that these persons now have to go qualify themselves as being a trained teacher? My thought exactly.
Yeah. Licensed to teach or authorized to teach, but I think you go further to say, should they have to be trained? Do they have to be trained teachers? The language needs to be changed. Where? In the report? In the report? Okay, what should it read? So we acknowledge the rationale given, that one? That sentence? So it should read, we acknowledge the rationale given for this position is that persons who intend to train teachers should themselves be licensed or authorized to teach.
Sorry, Chair.
Go ahead, Mr.
Right, I may have missed the decision given the technical problems, but that specific paragraph in the report, I think, is an accurate reflection of what was decided in the light of what is in the bill, in regard to the reason for that provision that was given by the ministry. So that if the concern is that the committee doesn't want persons who teach in an education program that prepares persons to become teachers to be regulated under the legislation, amendments would have to be made to clause 4G of the bill. So I think
what we're
it's
saying,
best
though?
to first. Oh, sorry. I just want. Okay, so I'm asking for clarification.
That's not what we're saying.
Right. I may have missed that portion where a decision was taken. So my question then is, has a decision been made to recommend amending clause 4G of the bill? And if so, what is that recommendation?
Madam Chairman, I know that Dr. Gordon is very sanguine on how speedy the council is going to be in providing responses. But I'm just looking at all the teachers that it has to deal with, the investigation,
and all the circumstances,
the investigations that it have to carry out, the breadth and the smallness of the team. So we have to look to try and ease the pressure from the organization as well. And so you have a tertiary institution with qualified teachers or educators running it. And we are saying that every person that participates in that course, they cannot participate unless the council get involved with the person who is teaching adults. I don't see why it is necessary. But I did say that I was not going to say anything more because I'm not adding anything to it. But I just do not see why the entire 500 people working at Braham's Teachers College should all be authorized to teach or qualified teacher when they are doing a BSc.
I think the council said that being a trained teacher was an error. So you just have to be licensed or authorized.
Not according to clause 4G. Clause 4G makes it very clear. This act applies. Well, I suppose according to 4G, that person then would have to be at least be authorized to teach. And I'm saying that the 500 people in Braham Teachers College, do you need every lecturer, assistant lecturer, part-time lecturer, tutor to come in, that you have to apply and sit down and wait for the authorization? That could take 6 months. I think we must be realistic how the system is, you know.
Member, can you go on the microphone, please?
They are, in fact, training teachers, yes, and they are training adults. That's 2. 3, I do accept that you must have the leadership and people in charge in certain departments have certain qualifications. But I'm saying that you ought not to need every other person in a tertiary institution teaching, lecturing, and that they have to get a designation from the council, whether as an authorized person or a qualified teacher. I think it is adding to bureaucracy for you to get me, let us say, Mr. Foreman is on the line there, and Mr. Foreman is to go to Brigham Teachers College, and he's going to teach law. I can't use him until the council issues an authorization. And I'm saying that's unnecessary. If Brigham himself is an educator who is supervising the program. But that is a view. I can't take it any further. If the committee believes that every dege person in the college must be so certified, well, so be it. Now, that is not to say in a high school every teacher should not be certified. That's not what I'm saying. I'm talking about the tertiary institution.
Council, can you go on microphone, please?
The amendment is Madam Chair, sir, our concern here is to ensure that the process of getting authorization to teach is not cumbersome. That's important, but if the institution is training teachers and somebody is going to be brought into that institution to train teachers, then there should be some level of satisfaction that this person is sufficiently exposed and qualified to train teachers.
That's different than what was represented earlier. If you're saying to us that the person have some level of qualification, are you saying to us that it does not have to be a prerequisite qualification to teaching? Person could have a degree in psychology, but that's not what is coming across. What is coming across is that the person in the first instance would have to get that authorization from the council and not the institution on its own, who could have made the determination that this person that is coming in to train some guidance counselors who, as it relates to D, yeah? D speaks to a guidance counselor or a dean of discipline. But you could have a trained psychologist coming in to prepare that person and to teach that person to be a trained teacher. The institution could, in the first instance, make that determination that this person is so qualified and does not have to seek the council's authorization. And what I hear Senator Braham to be saying is that, given all the layers of responsibilities of the council, it may take some time. If there's an immediate cause to fill that capacity of a trainer, you don't have to go through that level of the pre-authorization. The institution on its own can make that determination. Well, Dr. Gordon could tell us if they are required to do so now. That's my understanding. An institution can make that determination now.
So, at a tertiary teachers training institution, Senator Gale, who is a teacher, a lecturer there, migrates. And we have a situation now that the students need to finish the course for their exams. I suppose if Mr. Nash is discovered to be suitable, you could hurry up and put in an application to the council and hope that they would give him a designation so that he can teach. If the council doesn't give it, then they may not have somebody to replace in a timely fashion. The person may have it already, but there are lots of areas that people lecture in the teachers' college, that the people who are doing the lecturing is not necessarily a teacher. But they have teachers, teacher qualified people running the institution so that they will ensure that all the teacher-related matters are dealt with. So I am teaching something. I am not a teacher, but Senator Gale will deal with that part of it. I deal with the rest. Why everybody in the institution must be designated? It is unnecessary work for the council.
Is it that we're not getting the quality of teachers out of the teacher education institution? Just asking a question. All right, so we're going to have to do some further deliberations around this, maybe even speak with our teacher education institutions, or teacher education institutions. All right, so member will move on as we put an asterisk beside this for some further consultation.
So, in continuation, inclusion of definition of authorized teacher. Your committee noted the recommendation to include the term authorized teacher in the bill that refer to any person who would otherwise be refused registration as a teacher on the basis of not possessing the prescribed qualifications. The rationale for the proposal was to make it clear that persons such as pre-trained teachers and teachers on exchange programs could qualify for an authorization to teach. Your committee considered the definition of authorization to teach in the bill and did not accept the recommendation. We noted that where a pre-trained person or any other person who does not possess the qualifications to be a teacher needs to be employed, they would be eligible to be granted an authorization to teach if the conditions in the bill are satisfied.
What exactly that mean? Your committee considered the definition of authorization to teach in the bill and did not accept the recommendation. We noted that where a pre-trained person or any other person who does not possess the qualification to be a teacher needs to be employed, they will be eligible to be granted an authorization to teach if the conditions in the bill are satisfied. So, can you remind me what section deals with authorization to teach? Of the clause.
Definition clause. Check the definition clause.
29?
You want a microphone?
No. Not yet, not yet. A person may apply to the council for authorization to teach upon applying for a teaching position in a school, an approved home education program, or other educational setting to which this act applies. Subject to subsection 3, a person is eligible for the grant of an authorization to teach from the council if the council is satisfied that A, the prospective employer of the person is unable to find a licensed teacher who is suitable to fill the position. B, the person has the skills and expertise appropriate to advance the learning of a student or group of students. Or the person has skills that are in short supply. B,
Sound familiar?
the person has the knowledge, qualification, skill, or training reasonably considered by the council to be relevant to a teaching position that the person has been offered. E, the person is a fit and proper person to teach. The person has the English language skills. The person is not disqualified person, meets any other prescribed, and then it says for the avoidance of doubt, appearing to possess, and so on and so on. Okay.
What was the name?
3 and 4 up to 29. This is 29, and then she said, and then remove the R's up somewhere up there.
All right. Are you satisfied with that?
But I don't. That's why I don't understand how we have written this here. You see, it says your committee noted the recommendation to include the term authorized teacher in the bill, and that is there already. Am I correct?
Is this a different, I'm sorry.
Or authorization to teach is in the bill.
Authorized teacher wasn't there.
So is it because we have authorization why you're saying you don't need authorized teacher? Well, I'm not sure that's what we said that though. Your committee considered the definition of authorization to teach in the bill and did not accept the recommendation. We noted that there were, very well. I suppose what it is saying is that you have authorization to teach, and that's adequate. You don't have to have an authorized teacher.
That's what it's saying.
That's what it's saying. Okay? Teacher.
Right.
Right. Okay. You see,
I'm sorry, I'm not supposed to be speaking.
All right, to the technical team, what are we saying about this particular paragraph on page It's okay? All right. All right, please move on.
Definition of registers and role of instructors. Your committee noted the recommendation for the bill to better develop and outline the areas related explicitly to instructors, such as stipulating the maximum number of years a person can serve as an instructor. Your committee does not accept the recommendation and acknowledges the need to provide flexibility in determining who may be granted an authorization to teach, taking into account, in particular, the wide number of technical and vocational areas for which instructors may be desired. Under definition of fit and proper to teach, your committee noted the various queries made by one stakeholder concerning the scope and limitations of the definition for fit and proper to teach in the context of academic perspectives on competency and skills, right to privacy and protection from discrimination. Your committee does not recommend any changes to this clause given the detailed requirements for fit and proper to teach as set out in the fourth schedule of the bill. Definition of child and best interests of the child. Some stakeholders recommended amending the definition of child to be a person who has not yet attained the age of 20 years instead of persons who has not attained the age of 18 years. Similarly, stakeholders also expressed concern that the term best interest of child would not cover persons in schools who are over 18 years old. Your committee noted the definition of child in the bill is consistent with the Child Care and Protection Act. We also noted that in relation to best interest of the child, there was consistent with Section 2.2 of the Child Care and Protection Act, and that it would be difficult to modify this concept in the bill to apply to persons over 18 years old without introducing an inconsistency with the Child Care and Protection Act. Having regard to these matters, your committee makes no recommendation to amend these definitions.
This is an attempt to make people qualify for champs. Ryan Boys champs at 20.
Definition of disqualifying offense. You should talk about that with your school. Your committee discussed the definition of disqualifying offense, and members expressed concern that it would not cover particular instances of wrongdoing. Members also expressed concern that the offense should only cover the most serious crimes. The technical team was asked to revise the definition to refer to a discrete list of most serious criminal offenses, which was reviewed by the committee and approved. Your committee therefore recommends an amendment of the definition of disqualifying offense to refer to an offense listed in the schedule to the Act. Your committee further recommends the list of offenses outlined in Appendix 1 of the report. Clause 3, Objects of the Act. Subclause 3B4, your committee acknowledged the suggestion.
I think we should look at the appendix, though.
You want us?
There's an Appendix 1.
It,
Shares a list of offenses.
Yes.
yeah, we had gone through them in our previous
Yes, we
meeting,
had.
and I believe we had agreed on them.
Yes.
Very well.
Your committee acknowledged the suggestion to amend subclause 3B4 of the bill to include references to the interests of students and the interests of the wider society. Your committee recommends the inclusion of a reference to students' interests and that of the wider public in the objects of the bill. Clause 4, Application of Act. Subclause 4.1e, your committee noted the overwhelming request from the Jamaica Association of Homeschoolers and individual families of homeschoolers that the authorization requirements of the law should not apply to parents who teach their own children and no other children. Your committee recommends that the bill be amended to exclude the need of parents who teach their own children and no other children from being subjected to the licensing and authorization requirements of the law. Under subclause 4.1g, this clause extends the application of the legislation to persons who are engaged in programs to prepare persons to become teachers. Your committee acknowledged the suggestion that standards for teacher educators should be done after the standards of teachers have been established. Your committee noted that the standard for teacher educators could be particularized through regulations made under the Act. And in subclause 4.2...
So, hold on, Member Graham, does that answer the question that you brought up earlier on?
No, I mean, it just says that, sorry, it just say, as I understand it, that everybody still will have to be qualified. It's just that you will then designate it in a separate category when to do so. I am still saying that not all 500 instructors, lecturers at the place should be required. It should be limited to the management and the rest. They decide who else to come in to teach in their institution. But it is what it is.
Okay.
Subclause 4.2. Your committee noted the stakeholder query whether a person who teaches on an ad hoc voluntary basis should be excluded from the bill as the person is potentially susceptible to the same deficiencies and potential abuse which the law seeks to guard against in persons who teach full-time for pay. This stakeholder also questioned what would qualify as teaching on the ad hoc basis. Your committee agreed with the position reflected in the bill that persons who teach on an ad hoc voluntary basis without pay reward or consideration should not be subject to the registration and licensing requirement of the bill. In relation to the meaning of ad hoc, the committee was satisfied that the ordinary dictionary definition of ad hoc, where necessary, would apply. Clause 5, best interest of the child paramount. Your committee does not recommend any change to this clause. Clause 6, establishment of the Jamaica Teaching Council. Your committee does not recommend any change to this clause. Clause 7, functions of the council. So under clause 7, your committee acknowledged the recommendation to amend the bill to clarify the functions of the Jamaica Teaching Council and the University Council of Jamaica, as there were perceived overlaps or duplications of functions of the two entities. Your committee did not agree that there were overlaps and duplication of functions, and therefore does not accept the recommendation. Under subclause 7.1e subsection 3, your committee noted the recommendation to remove subclause 7.1e subsection 3 in consideration that identification of certain categories of persons would be done to the exclusion of others. Your committee does not accept the recommendation and noted that the provision is sufficiently wide to capture other instances of authorization to teach. Under subclause 7.1g, your committee noted the recommendation to remove the subclause because regulation of practice of teaching is outside of the objects of the bill and would not be practical, as the council would not have the capacity to regulate the services provided by all teachers in Jamaica. So your committee recommends that the provision should be amended to read, G, regulate the practice of teaching profession. Quote, end of quote. under subclause 7.1i, your committee noted the recommendation that the development of a professional learning framework by the council be done in consultation with relevant stakeholders. In particular, your committee considered the proposed insertion of the words, in consultation with the stakeholders in the education sector, develop and maintain, adapt, or incorporate and apply a professional learning framework to support and promote the continuing professional development of registered teachers, licensed teachers, and instructors. Your committee does not accept the recommendation as formulated, but recommends that the provision should end with the words, in consultation with bodies engaged in teacher development.
Where is that?
That is subclause 7.1. Yes. In consultation. Well, I was following them. So, moving to subclauses 7.1, 1.3, L3, and M. You have to look clearly to see the size. Yes, the font. Your committee noted the recommendation to remove the clauses given that the monitoring and conducting of professional appraisals are really the function of regulatory body. In relation to subclause 1L3, it was highlighted that the subclause addresses the monitoring of professional appraisals for teachers, while subclause 7.1LM subclause 1M treats with the evaluation and not the appraisal of a special category of teachers called master teachers who are designated nationally. And so your committee recommends the subclause 7.1L3 should be retained while subclause 7.1M should be removed. Your committee also recommends that it should be recognized that master teachers currently operate in the council. And so there are some...
What do you mean by currently operate in the council? It says here that it should be recognized that master teachers currently
Mr. Foreman, do you wish to just summarize to help us to understand
Sorry,
the gist of what you have
yes,
there?
thank you.
Yeah.
Thank you, Chair. So I recall the comment that was made by the stakeholder here came out of a concern that these provisions would, as I understand it, allow the council to, go into all of the schools in Jamaica to conduct, essentially employment type appraisals of all teachers. And I think the concern was that something of that nature would not be practical. And the response that was given was that the provisions were intended to apply to categories of teachers who were designated at a national level, and that master teachers was the example given. So my note says the provision in question 7.1.3 does not treat with the evaluation of master teachers. The provision makes the conduct of professional appraisals one of the council's functions. So it's not limited to any named category of teachers. Furthermore, the provision is not limited to master teachers because there are no limiting words to that effect. If the committee wishes to acknowledge the rationale given by the technical team for the inclusion of the provision in the bill, please consider revising the language of this paragraph in the report to say that the committee was advised that the intention of the provision is to list as one of the functions of the council, conducting appraisals of specialist teachers designated as such by the council. And the second comment I made relates to the decision to delete the provision that speaks to conduct of professional appraisals being one of the functions of the council. The committee is invited to reconsider that decision. Subclause 7(1) L3 states that the council should monitor and ensure compliance with professional appraisals. Subclause 7(1)M, which is the clause that comes immediately after that one, states that the council should conduct professional appraisals. It appears to me that the two provisions are intended to work together. The latter relates to conducting appraisals, while the former relates to monitoring and compliance, something that I assume would be done after the appraisal. So if the intention of these provisions is to acknowledge that a function of the council will be to assess teachers who are designated by the council as belonging to particular classes of teachers, such as master teachers. Suspect there may be other special classes of teachers that the council may wish to create and designate. These provisions perhaps should remain, but part of that will depend on what the intention of having the provisions were in the first place. Thank you.
Chairman, I am wondering, you see, the question of removing, I don't expect that the council for every teacher would necessarily be carrying out every aspect of their responsibility every year. But what if, as I have had the experience, Teacher Braham is teaching at X school, and the complaint is that Teacher Braham doesn't know anything. He's teaching, but his content is lacking. Would the council, without the authority to assess professional qualification, be able to investigate whether Teacher Braham in fact lack content, or is that something that the council is supposed to be doing? Is that something of importance? I don't know if you're following what I'm trying to say. So the complaint is that I do have my qualifications, however I got them. But when I stand up before the students and I'm teaching subject A, it appears that I don't know anything about subject A or sufficiently, even though I have the qualification, my BSc and MSc and so on. Is that something that the council should be able to look into? Because it happens. And if you take out this qualification requirement, would they then be denied the right to do so? And these are genuine questions. It is at 7. Conduct professional appraisals. Would the council be able to look into the scenario I just established without that particular, or you can use that? Is that something that the council should be able to do, or should that be left to the school? Now, I am leaning to the fact that the council should be able to do it from time to time. I'm not saying that the council is to carry out an appraisal of every teacher every year and so on, but they should have the power to do so when called upon on where it is necessary. I wouldn't mind hearing.
Sorry, my view on that would be, so the council, in my mind, could not, Member Braham, do the consistent appraisal. That would be left up to a grade supervisor of a particular discipline. It is when you have a situation where you may have identified that Teacher Braham having had the qualifications, because the qualifications would make the person eligible to pass the post and to be employed, but just certainly can't deliver. And there are complaints around the delivery. The school now would ask the council to make a formal assessment or a formal appraisal at a particular level to make a determination. So it removes the level of subjectivity that would be stipulated at the level of the institution alone and gives a rise of another level of where, and this other level now, Senator Braham, was intended for it to be a level of outside independence of the school, because that teacher could say, the grade supervisor or the principal don't like me, and so they want me out. But the council now would be at an independent level to better able to treat with what you are suggesting, if you understand it that way.
Dr. Gordon? The way you put it, Senator, Member Gale, makes sense.
That I would like the council to have the authority to do it.
To step in.
I don't expect the council to be assessing every teacher every year for thousands of teachers. That makes no sense. But if you get a complaint about me, a parent makes a complaint, and them say the parent say, well, I spoke to the administration, they're not doing anything. They should be able to look into it. And so I will keep it.
So members, there's a recommendation that both subclauses be retained, with the council having the power to investigate if there's a complaint. Dr. Gordon, does that sound correct? Dr. Gordon, do you wanted to add something?
Chairman, I'm thinking that the council really should have the right possibility to conduct an appraisal on the request of the board or the body that is responsible for supervising the teacher. And so we could put may conduct instead of having conduct in M, at M, we could say may conduct professional appraisal. And that gives the council the opportunity to do so should it become necessary.
So I put that to members.
Well, sorry, may I say something there?
Yes, please go ahead.
Subject to any comments the drafter may wish to make, the structure of clause 7.1 is to have all of these functions be requirements of the council. So the chapeau says, subject to the provisions of this act, the functions of the council shall be to, and then it lists everything. I mean, notwithstanding the fact that it says the function shall be to do all of those things, I would think it would be within the council to make regulations that govern the conduct of professional appraisals, so that those regulations would provide the limiting framework that would make it clear that it's not a situation where the council is going into every single school to conduct appraisals of every single teacher. In other words, it may not be necessary to change anything.
Sorry, just to understand, Mr. Foreman, could you read what you had proposed? I just want to get the gist of it. So we're not supporting or suggesting that the council ought to just go in and just do appraisals. It must, in my mind, a situation where it is called upon. So there's a particular trigger to doing it, but give rise to the fact that the council can, in fact, conduct these appraisals. In other words, if I'm asked to do it, I must be able to be, as the council, come in to do that assessment. So it's a question of if required, not an automatic reach.
Okay. Thank you. My recollection, Senator, is that there are no specific provisions in the body of the bill that indicate how these appraisals are to be done. So if the committee wants to make those things explicit, those conditions explicit in the primary legislation itself, words to that effect would need to be inserted. What I was suggesting is that given the fact that this is a function of the council and the bill says functions include powers, and given the fact that the council, given the fact that there are regulation making powers in the legislation, that the regulations could serve that purpose as well. But I say all of that subject to any concerns the drafter may have. So if the committee wants to insert language in the primary act, specifically setting out the conditions in which appraisals can be done, that's usually the ideal. If you know what you want, put it in there. That removes any doubt about what was intended by the legislation. But if that's not there, the other option is to leave that to regulations made under the law, and perhaps specifying as one of the matters for which regulations may be made the conduct of professional appraisals, if there's a desire to make that somewhat that clear.
Chairman, I slightly differ from Senator Gale as to whether or not you need to put specific circumstances under which they may conduct a professional appraisal. I think they should be left to treat with it as they treat with all the other powers that they have. Where it is necessary, they apply it. I don't think that there is going to be the likelihood that they'll be doing thousands of evaluation every month or every year for every teacher. I don't think we need to say that this is a situation you must need it. It may well happen that you need an evaluation and we didn't specify the circumstance that don't fit in there when one is necessary. I wouldn't agree with my good friend.
I note that you never differed far by way of your statement. When I look at the other functions of the council under 7, in my mind, they are specific in scope. In order to fulfill the mandate of the council must carry out these functions. They have the authority to do so, and they must under the scope of the law. Where I was having a difficulty was how it would conduct a professional appraisal when it's not the supervisor of the teacher as immediate. So it is the other scopes are targeted, they are specific in nature and must be conducted by the council. It would be challenging for the council who don't supervise the teacher to be asked routinely as it's suggested here, because it's just placed here to conduct professional appraisal. And I'm saying there has to be a distinction as to how you are called upon as a council to conduct the professional appraisal. And there must be a trigger to it. So it is language by the drafters to suggest how this can be applied. And it's not one of these areas of function that is expected to be routinely done.
Hello? Can you turn your microphone on, please?
Member Gale, if we look at, we had deleted M, 7M, in that discussion. And then now, we are looking at the possibility that the council could be asked to carry out an independent assessment appraisal of a teacher, in which case we would keep M, but we'd put may conduct. And then the regulations would set out under what condition the council may conduct.
All right, that seems acceptable. Yes. All right. All right, great. So please continue, member.
Sorry. We're at that stage, so I just want to be clear on what the decision is. So the decision is the committee is reversing into earlier decision, and you're going to recommend that there be no changes to these two subclasses.
I thought, though, Mr. Foreman, that we would be including Emma on the clause 7.1. Is that 171? M was taken out, and we're saying for it to be put back in, but to add may conduct professional appraisals.
Right, and that
please go on microphone.
Precise formulation couldn't work in the context of the clause 7.
Please go ahead.
So perhaps the committee may want to decide that these provisions should remain, and that the recommendation is that the bill should indicate that the council may conduct these things, and then leave it to the drafter would need to provide a formulation that works within the context of the bill.
That's essentially what we have said.
That would be a separate clause then.
No, you insert may.
So you wouldn't put M. You wouldn't put it at M because it's discretionary. So
right.
you would have to put it under this discretionary provision. The drafter will treat with that.
So why wouldn't you not be able to simply put in probably a clause to say that it is up to them to determine when to exercise any or all of the powers that they have?
Senator, just because that clause starts with shall.
I know, but I'm just saying that if you had a separate subclause to say that it is up to the council to determine when appropriate to apply any or all of the items from A to L, and that would make all of them discretionary. And I'm not going to argue about it. I mean, once it remains so that they can do it, I am happy.
All right, so the drafters will find a place for that, for the council to exercise its discretion at conducting professional appraisals, whether it be via a complaint or otherwise. Please carry on, member.
Subclause 72G, your committee recommends the deletion of the term paraprofessionals. And subclause 71P1, no, 1P1. No, is I. Your committee highlighted the recommendations to move subclause 71P.I. You see, it's 1 and 2. It's not I.
It is, yes, it seems. Yeah, well, anyhow.
It's Roman numerals. It's Roman numerals 1, 2, 3. See it here? 1, 2. So it is subclause 7, 1, P, 1, and 2. To subclause is Roman numerals. To subclause 7.3D, 1 and 2, so that the council is given a discretion to consider and make recommendations to the minister on the matters referred to in subclause 7, 1P, instead of having an obligation to do so. Your committee does not accept the recommendation. The function in subclause 7, 1P are to remain obligatory and not discretionary. Clause 8. Council to have regard to certain matters in exercising the functions of the council. Your committee does not recommend any change to this clause. Under clause 9, delegation, your committee does not recommend any change to this clause. And under subclause 10, professional standards. Your committee noted the query whether the professional standards would apply to different categories of teachers in the same way and at the same rate. Your committee notes that different standards may exist for different categories of teachers and that any such distinction would be made in regulations. Under subclause 10.1, your committee acknowledged the recommendation to include the words, in consultation with Teachers College of Jamaica and representatives of the various educational institutions in relation to the development and maintenance of the professional standards. Your committee does not accept the recommendation as formulated and instead proposes the inclusion of words to the effect of in consultation with stakeholders in the education sector. This was being specific.
Yes.
So, Mr.
Right.
Foreman.
Sure.
Yeah.
Oh. Yes, I think my comment was based on perhaps an earlier draft of the report. So it doesn't apply to what's there.
It doesn't apply as it is now.
Right. So
Right.
I think I'm comfortably withdrawing.
So we can move to clause 11. Continuing professional development. Your committee noted the request for clarity on the core traits of effective standards for teachers that are to be reinforced and promoted in the Continuing Professional Development Framework, CPD. Your committee acknowledges that the details of the CPD will be set out in regulations and would not be appropriate for inclusion in the bill. Under subclause 11.1, your committee acknowledged that the recommendation to include a requirement for consultation in the development of CPD was similar to the recommendation in relation to the development of professional standard for teachers. Your committee recommends that the provision be amended to include consultation with bodies engage with the teacher development. So, Mr. Foreman, the committee should clarify what is intended, because it's the same application, the same query as previous?
Yes, but I think this one is now accurate.
Okay.
I think the general point that was being made by the stakeholders here was that they wanted to ensure that there was a duty to consult
Right.
in the development of these professional programs, etc. So if earlier the recommendation was consultation with stakeholders in the education sector, perhaps this for consistency, the same sort of language should be used.
So where the,
of course, that
where
would
the
give
previous
discretion.
one had education sector, this one was saying those bodies engage in teacher development. So you are proposing for there to be some level of consistency with the considered grouping for consultation.
Yes, though I suppose the argument would be made that in relation to professional standards, different types of persons in the education system might be more appropriate than
It's broader.
when it relates to continuing professional development. My recommendation is that this might be one of those areas where you leave it up to the discretion of the council to decide, who is best to consult in relation to this type of area, so that the language used, the recommended amendment to subclass 10.1, stakeholders in the education sector. I think that's arguably broad enough and decipherable enough in terms of what it means to achieve that balance between a duty to consult and a discretion to determine the best persons to include in that consultation.
Chairman. I was listening to Mr. Foreman, and he had said that his original thought do no longer apply. But when I look at it, the first one, when I looked at it, I'm wondering if he's not too hasty to say so. So the council is required to consult people, stakeholders, and other persons involved in teacher development. That is a very broad thing, We could well have disputes as to exactly what that means. I mean, what I have seen in other legislation is that the council may consult with entities or persons who, in its opinion, represent stakeholders or something like that. But just to say to consult stakeholders, does that mean every nook and cranny and every stakeholder, including Ransford Braham, who has a peripheral interest in education, should be consulted? I can see lawyer Cavan Gale making heavy weather of it. I don't know that we should put it that so general and wide. I wonder if Mr. Foreman will reconsider his position.
So,
Senator Braham, I'm but a mere advisor. If the committee
yes, and so I'm asking for the advice. Is advice I'm asking for, nothing else.
Yes, your point, former Attorney General, is well made, and that formulation may well be the better.
I guess at that
Thank
point
you for
we
the
leave it
advice.
alone. I guess at that point we leave it alone.
All right, carry on.
So we can move to subclause 11.2b. No. Oh, sorry.
No, need to decide.
So Senator Braham, you are right. If you broaden it to the education sector, it means every grouping that would fall under the rubric of the education sector. And so someone could say that we were not consulted when the council would determine and invite who they want to consult with. My preference is for it to be sharp and focused in terms of who you want to consult with.
But you see, we are not going to be able to properly set out, because organizations and entities come and go. So this act is for the long term. I think that even though the best formulation is to get the council to determine who represents people in the industry, so to speak, and consult with those people. There are some people who are well known. Or you may wish to say organizations representing teachers. I don't know.
No, but currently member in the education sector, a lot of consultations go on with regards to policies, all over, lots of consultations. And I believe that over the years they've developed long lists of entities to whom they send letters and may call on a virtual call or at a conference. So I would not be particularly concerned with this, just because the sector has had a long history of what consultation looks like, who are the stakeholders, and so on.
Well, I think, Minister, you are too optimistic. You don't consult with me once. I usually consult with 50 people, and one reason or the other, I am dropped off the list and see what I do. I think that we should reconsider whether or not it is too broad and circumvent it a bit. But I leave it to you.
Hi, sorry. Minister, may I?
Yes, please go ahead.
Just point out that in relation to, there's an example of what Senator Braham recommended that's already in the bill. So, for example, in the schedule related to the board of the Teaching Council, but I'm not sure if this was later amended. But the minister is given the discretion to persons to sit on the board from various categories. And the language used, for example, in one provision is, registered teachers, certain number of registered nominated by an association, recognized by the minister as representing the majority of teachers in Jamaica. So I think what I get from Senator Braham's intervention, which I think is prudent, is to structure the recommendation in a way that makes it clear that the council is the one that is given the discretion to determine the persons with whom it should consult, so that it's not too open-ended, in other words.
All right, member, please carry on.
So we move to subclause 11.2b. Your committee acknowledged the recommendation to insert the words, shall consult with the owners of schools, as well as such bodies that are, in the opinion of the council, representatives of the majority of teachers. Your committee recommends that the provision should be amended to include consultation with stakeholders in education. Again, Mr. Foreman.
Go ahead, Mr. Foreman.
My note says the committee is asked to reconcile this decision with the decision it made in relation to subclause 11.1. Clause 11 contemplates consultation in subclause 2. So this would be the appropriate place to indicate entities that should be consulted. So I'm suggesting that the recommendation that was made in relation to subclause 11.1 should really apply to 11.2. I suppose that a technical point.
So, Mr. Foreman, I don't recommend that we indicate the entities that should be consulted with. I think it has to be situation specific. List representatives of the majority bodies, such as, but I think it should be, we shouldn't be as prescriptive as to list the stakeholders.
Okay.
CFO.
Yes, I agree with that. It's a question of what the language should be.
All right, so can we leave that with the drafters?
Yeah, I can.
Yes,
sure.
to help us with the language. Carry on, member.
But sorry, but just to be clear, so the basic idea is accepted, which is that there should be some consultation in the development of these types of things, and what needs to be done now is to clarify the precise recommendation in terms of the how the discretion is to be exercised and the bodies with the bodies to be consulted if any is to be mentioned at all in the provision.
So what we're saying is that in the first instance, the principle of consultation is the overarching objective. And then the minister can determine who to consult with. The council can determine who to consult with. But the principal overarching objective is that consultation should take place.
Understood. We can work something out.
Okay. So we move now to clause 12, establishment of board of governors. It says your committee does not recommend any change to this clause. And clause 13, functions of the board. Your committee does not recommend any change to this clause. Clause 14, ministerial directions. Clause 14, your committee considered the recommendation to delete the clause to avoid inefficiencies and waste caused by bureaucracy, political interference, nepotism, corruption, and abuse of power by persons holding government office. Committee said all of that? Oh. Your committee does not accept the recommendation and notes that this is a usual provision in legislation in Jamaica, that the clause is limited to such direction of a general character as to the policy to be followed by the council. Right. Clause 15, cooperation between council and other authorities. Your committee does not recommend any change to this clause. And under clause 16, obligation of secrecy, your committee does not recommend any change to this clause. And with 7 minutes to go. Clause 17, disclosure of information in certain circumstances. Your committee does not recommend any change to this clause. And under clause 18, appointment of officers and other employees. Your committee recommends that the clause be amended to make clear that board will appoint the chief executive officer and the council shall appoint the attorney at law, registrar, and such other officers mentioned in the provision.
But why are we doing that?
So Mr. Foreman, your notes is saying it is unclear who or what the council is for this purpose.
Why are we going down in such minute detail saying that they can only appoint certain people? It says...
Sorry, Senator Graham, there's a general provision at 18(1)(d). Such other officers, employees, and agents as it thinks necessary for the proper carrying out of the provisions of the act.
And so we had to take that out? No.
No,
So what the
that remains.
the recommendation is that the clause be amended to make clear that the board will appoint the chief executive officer and the council shall appoint the attorney. I don't think that is necessary.
Well, this is one of the issues that we flagged as an area where there's it's unclear what is the board and what is the council for specific types of decisions. In other legislation where entities are created, the general structure is that you have the entity and you will say that the entity has a chair and so on and so forth. And then there's a provision that will say the entity selects a CEO, and then another provision that says the CEO is empowered to hire other staff. And some legislation specify that there must be certain categories of staff, and then a general provision as obtains here. So my recollection from the discussion is that when this came up, some members asked the question, well, who exactly is how does the council go about appointing the CEO? Because it wasn't precisely clear who is the operating mind of the council in this context. So the recommendation was made that the bill indicate that the board would be the entity that decides who the CEO is. And then what would be left is the council hiring everybody else. I think there's an assumption. Well, I don't know. The point of my comment is that it's not clear to me how that would work.
So how is it, Mr. Foreman, how is it written then for a company, let's say NPL, right? That's a company, it has a board. The board selects, hold on.
A regular agency, the board would recruit and employ the CEO who reports directly to the board. And then the management, other layers of management would do the recruitment with other operational skill sets. I'm seeing here where, because they're using and applying the same concept, where the board takes on the CEO and then the council that is operational in nature would do the recruitment of the other layers as defined in 18(1)(a), B and C and D, such other officers.
Chairman.
This is where Senator Braham is going to disagree with me now.
It's just because we're using the
Only
word
occasionally, though. That's a good thing. Only occasionally. The board is supposed to be the operating mind of the council. Am I correct? Of the council. And so it is the operating mind of the council. Well, how does it work? So is it different?
Remember, I think it's because we use the word council. It's set up no different than a company that has a board. But it's because in the name of the entity is the Jamaica Teaching Council. I think we get a little bit confused and hung up on that. It's consider that the company, the Jamaica Teaching Council.
The act or the bill that's supposed to make that clear. But that's fine. But I cannot understand why we want to say that the executive director is be appointed by the entity, whether board or council, right? And then the executive director now appoint everybody else?
No.
Why would we do that?
But
The
that's why it says the council. The council
I am listening to suggestions
consists of
that
other
the
functionaries.
the council, there is a suggestion here, you know, Minister. It says, committee recommends that the clause be amended to make clear that the board will appoint the chief executive officer and the council shall appoint the attorney, registrar, and such other officers. So I don't understand that there is a clear difference in this recommendation between board and council. And I thought that the board was the operating mind of the council. What is the difference? Yeah. And the council is what? But the Jamaica Teaching Council cannot be anything but the operating mind of it.
But the Teaching Council has a board.
That's the point. But the recommendation says the board appoints the chief executive officer and the council appoint other people.
So can I ask you though, because you've chaired a board, right?
Oh dear.
That entity, the board of that entity would select the CEO, right? And then it would leave the entity and its various functionaries to do the hiring, the HR management of all these other persons that need to be hired.
Say the council shall employ everybody and leave it at that instead of going divide the board and the council, because to me it creates confusion. The council appoints the chief executive officer and anybody else they wish. Usually what the council or the board of the council would do is to delegate the responsibility for the other people, but it has a supervisory jurisdiction. When you say one person appoint and another person do something, you create confusion.
So accepted, member. Mr. Foreman? All right, I guess we are... No, man, he says it's unclear who or what the council is for this purpose. But I'm agreeing with member Braham that rather than making a distinction, it's the council as a body with all of its different entities that will be carrying out the hiring of the different persons within it.
So, sorry, so Chairman, just to be clear, so is the decision that the clause should actually remain as it is? The unamended clause says the council may appoint an employee at such remuneration and on such terms and conditions as the council thinks fit. All of these various persons, CEO, attorney, registrar, etc.
Yes, Mr. Foreman, that's what we're saying. It should go back. SG, please go ahead.
Hi, thank you, Chair. You will recall at the beginning of the meeting, one of the first issues we highlighted from the chambers was the board and the council. And Mr. Foreman didn't really go into detail, but there was something written in the report that we don't agree with, where it said you are going to make a distinction between the board and the council. And you could do that because the functions were discrete and so on. That's not so. And remember, we said that it may have been better for you to go through the rest of the deliberations and then come back to that issue. I humbly suggest that this issue should be decided after you decide what you're doing with the board and the council, because now nobody really understands the composition of the board as opposed to the composition of the council. Nobody understands the functions of the board as opposed to the functions of the council. And if you read the bill right now, there are overlaps. It's not clear, which was the reason we were suggesting at the outset to leave that decision for later on. And I suggest that this decision would need to await the decision about when you make the distinctions with the board and the council. Just to also say, we have a lot of other legislation where you will have the board appointing the head of the entity, and then the head of the entity appoints the staff. We also have legislation where the board appoints everyone. There is usually sometimes, though, a practical issue because the board only meets however often, and when it comes on to hiring staff, and you're talking about staff like a data clerk, entry officer, so on, it gets held up. So this is why, for practical purposes, the board doesn't always get that power, and it's not usually left to delegation. A lot of times you will see that it's very specifically outlined in a law who appoints whom. And a lot of times the board, sometimes a minister will appoint the head of the entity, and then you'll have that head of entity being given the power in the act to appoint all the other officers and staff. Usually, again, as I said, for practical purposes and for just for administrative efficiency and so on. But I really do think that this committee can't take an informed position until you sort out the differences with the council and the board. Thank you.
I partially agree with the Solicitor General. I am not clear what is the difference between the board and the council. I think that the council should be the council, and the council comprise of these persons who have been appointed in accordance with the particular schedule. And that is the body that is the council. When it meets, it has the double function as a board, all of that. I don't understand why you need a board separately from that entity that we define as these individuals that have been appointed in a particular way to run the affairs of the business. That's me. That's one. I don't know why you need a board separately, but at the end, as the solicitor recommend, I am going to be educated. So I'm going to leave that. I would not agree, though, that whether it is the council or the board, that the board and or the council be given the responsibility to appoint the chief executive officer, and the chief executive officer appoint everybody else. I think the better way is that the council has the authority, it appoints a chief executive officer, and it delegates the responsibilities for everybody else. That's how I've seen it operate, and it doesn't create a problem. On the other hand, if there is an issue in the organization, the chief executive officer is not conducting him or herself in the way in terms of employment practices, you might hear that the board and or the council have no authority over such matters. So that's why I'm concerned to do it that way. But I will wait until the end, and maybe I will look and see exactly what's the difference. I suspect there's no difference between the council and the board, but so be it.
Or, go ahead.
I will just finally say I agree with the first, when we started this meeting, the SG would have indicated that, whilst we go through, we are going to be identifying these possible overlaps distinctly. I recall when we're doing the deliberations, we spoke about it, the role of the council, the role of the board, and we had lengthy discussions in terms of the role of the PPC. And they're right. Let's go through, let's identify those areas that distinctly creates the overlaps. And at that point in time, we can determine what is fish or what is fowl.
Okay.
So member, just complete clause 19 and then we pick up, at part 3 the next time.
Pensions, gratuity, and other retiring benefits. And it says, your committee does not recommend any change to this clause. That's a good way to end.
All right, thank you, members. I think we're at a point where we'll have to end. Let me say, in terms of next meetings, hold on, I have a date. I have a couple of dates here. May 2nd. All right, May 16, 2 p.m. It's a Thursday. 2 p.m. It's a Thursday. All right. So let me thank everyone. We're on the home stretch. So we'll see you again May 16, 2 p.m., which is a Thursday. Is there any other business? All right, this meeting is adjourned. Thank you so much.